Hello all. Today we are here to discuss the very interesting topic of discharge of contracts. So let's start with a question.
Okay, so why do we enter into contract?
Two parties enter into a contract because they want something from each other. Say you and I enter into an agreement. We of course frame the agreement into a contract because we want it to be valid and enforceable by law. After both you and I have completed our obligations to each other, the contract stands neutralized. This point of neutralization is what is called as discharge of contract. Any situation, in fact, in which a contract is terminated along with the rights and obligations that go along with the contract is essentially discharge of a contract.
That jargon seems complicated. Wait, there are multiple ways to discharge a contract?
Absolutely. Like the 6 sides of a dice, there are 6 ways to discharge a contract. So let's roll the dice and see which way pops up. The first way to discharge a contract is by performance. Say for example, Shishya agrees to sell her car to Shruti for a sum of rupees 3 lakhs. Now the discharge of the contract occurs at the point when the delivery of the car is given to Shruti and she pays the sum in total to Shishya. It is important to note that when discharging a contract, there is a certain standard required of the obligations. Within this framework, it is also possible that the contract is discharged by attempted performance or tender. The next way to discharge a contract is by agreement or consent. Let's take a fictional scenario. Say for instance, a certain Harvey Specter wants to open a law firm with a certain Mike Ross. But before their law firm opens, Mike Ross gets an offer to be an investment banker. As for Harvey Specter, he decides to move to another country. Now in this context, the contract stands nullified due to the fact that they both agree amicably not to open their law firm. Thus, we can see that if such an agreement occurs, there must be accord and satisfaction. Since they had other options to fall back on and they agreed together not to open the law firm, there is accord. As for satisfaction, which can be loosely translated to mean consideration for our purposes of a contract, the consideration in this case would be that they both rescind their rights to open the law firm. Now for the next part, Shishya is going to take over and explain the next 2 segments.
Thank you, Jafreena. And now we'll be talking about discharge of contract by impossibility of performance. So take this example, when both the parties have performed their obligations, the contract is discharged, right? However, in certain situations, impossibility to perform the obligations also leads to discharge of the contract. I'll give you an example to make it easier. For example, A and B, both of them enter into a contract, which says that B says to A that I'll pay you rupees 1 lakh if you marry my sister. And they decide that he'll marry his sister next year maybe. And next year, B's sister meets with an accident and dies, unfortunately. So in that situation, the contract itself has been discharged because the basic subject matter was to marry his sister who doesn't exist. Therefore, it is impossible for A to marry his sister, right? So that is impossibility of performance. Now, impossibility of performance can occur due to numerous situations, like there has been certain change in law or destruction of basic subject matter which was essential to the contract as seen in the example, or declaration of war maybe. So there are n number of examples which leads to impossibility of performance. Now, impossibility of performance may exist for 2 types. Firstly, it may exist even at the time of agreement, like both the parties had entered into an agreement and even at that time it was impossible to perform the agreement. So in that case, the agreement itself is void ab initio. Or when parties have entered into a contract but it has subsequently became impossible to perform, which is also known as doctrine of frustration. So that's how, by impossibility of performance, the contract is discharged. Now this 4th provision for discharge of contracts is by the lapse of time. So the Indian Contract Act and the Limitation Acts make certain provisions where both the parties, I hope you know that there's a promisor and there's a promisee, right? So if the promisor fails to perform his obligation and the promisee fails to take reasonable action within a specified period of time, then he cannot seek remedy within law. So previously when I read this provision, I felt that it was quite unfair on the part of promisee that he doesn't get a chance. But later on I realized that the following provision has been made because the law thinks that the plaintiff has to be diligent enough about his rights. The Code and the Limitation Act gives you a reasonable time to approach the court after the breach. And if you are not diligent enough about your rights, so the court assumes that you don't care enough, right? So that's why your contract discharges because of the lapse of time. Okay, Shruti, over to you.
Thank you, Shishya. I will be speaking about discharge of contract by operation of law and by breach. In the case of discharge of contract by operation of law, the rules of law work to discharge a contract in certain circumstances. Circumstances like merger, insolvency, material or substantial alteration within the terms of the contract without the consent of either of the parties, or death of either of the parties in a case where the performance depended on the personal skill or ability of either of the parties. However, if it did not depend on the personal skill or ability, then the legal heirs of the party can perform the contract. An example of discharge of contract by operation of law would be, for example, if I make a contract with Shishya to use her apartment as an art studio for a period of 2 years, let's say, and before the expiry of the contract, I purchase the said apartment from Shishya. In this case, the earlier contract is merged with this new superior contract. The earlier contract, that is for the rent and the possession of the flat, is merged with the superior contract where I get the ownership of the apartment. This is a case of discharge of contract by operation of law, specifically merger. A contract can also be discharged by breach. Breach of contracts can be of two types: anticipatory breach and actual breach. In the first case, either of the parties to the contract either does an act or states that they will be unable to uphold the material condition of the contract before the due date of the performance of the contract, or does an act which makes the performance of the contract impossible before the due date of the performance. Anticipatory breach can be expressed or implied. For example, if I make a contract with Jafreena to purchase her guitar on a certain date, and before that date she sells her guitar to Shishya, this is an example of anticipatory breach. In this case, I can either sue for damages immediately, or I can treat the contract as operative and sue for damages on the due date of performance of the contract. In the case of actual breach, the party refuses to or fails to uphold the contractual obligations on the due date of performance of the contract, or during the performance of the contract refuses to complete their contractual obligations. In either case, that is anticipatory or actual breach, the party not at fault has several remedies. Remedies like suit for damages, specific performance, injunction, quantum merit, etc. So these are the 6 types in which a contract can be discharged.